Definition of state, Article 12. Article 12 defines the term state as used in different articles of Part 3 of the Constitution. It says that unless the context otherwise requires, the term state includes the following. 1. The Government and Parliament of India, that is, Executive and Legislature of the Union. 2. The Government and the Legislature of each state, that is, Executive and Legislature of states. 3. All local or other authorities within the territory of India. 4. All local and other authorities under the control of the Government of India. The term state thus includes executive as well as the legislative organs of the Union and states. It is, therefore, the actions of these bodies that can be challenged before the courts as violating fundamental rights. A. Authorities. According to Webster's dictionary, authority means a person or body exercising power to command. In the context of Article 12, the word authority means the power to make laws, orders, regulations, bylaws, notification, etc. which have the force of law and power to enforce those laws. B. Local authorities. Local authorities, as defined in Section 331 of the General Clauses Act, refers to authorities like municipalities, district boards, panchayats, improvement trust and mining settlement boards. In Mohammad Yasin vs. Town Area Committee, AIR 1952, the Supreme Court held that the bylaws of a municipal committee charging a prescribed fee on the wholesale dealer was an order by a state authority contravened Article 19(1)(g). These bylaws in effect and in substance have brought about a total stoppage of the wholesale dealer's business in the commercial sense. In Shri Ram vs. the Notified Area Committee, AIR 1952, a fee levied under Section 294 of the UP Municipalities Act, 1919, was held to be invalid. C. Other authorities. In Article 12, the expression other authorities is used after mentioning a few of them, such as the Government, Parliament of India, the Government and Legislature of each of the states and all local authorities. In University of Madras vs. Santabai, AIR 1954, the Madras High Court held that other authorities could only indicate authorities of a like nature, that is, ejusdem generis. So construed, it could only mean authorities exercising governmental or sovereign functions. It cannot include persons, natural or juristic, such as a university unless it is maintained by the state. But in Ujjambai v. State of U.P., AIR 1962, the court rejected this restrictive interpretation of the expression other authorities given by the Madras High Court and held that the ejusdem generis rule could not be resorted to in interpreting this expression. In Article 12, the bodies specifically named are the Government of the Union and the states, the Legislature of the Union and the states and local authorities. There is no common genus running through these named bodies, nor can these bodies, so placed in one single category on any rational basis. In Electricity Board, Rajasthan vs. Mohanlal, AIR 1967, the Supreme Court held that the expression other authorities is wide enough to include all authorities created by the Constitution or statute on whom powers are conferred by law. It is not necessary that the statutory authority should be engaged in performing governmental or sovereign function. On this interpretation, the expression other authorities will include Rajasthan Electricity Board, Cochin Devasum Board, Cooperative Society, which have power to make bylaws under Cooperative Societies Act, 1911. The Chief Justice of a High Court is also included in the expression other authorities as he has power to appoint officials of the court. The President, when making order under Article 359 of the Constitution, comes within the ambit of the expression other authorities. In effect, the Rajasthan Santabai's case, holding a university not to be the state. And finally, The Patna High Electricity Board's decision has overruled the decision of the Madras High Court in court, following the decision of the Supreme Court, has held that the Patna University is state. In Sukhdev Singh vs. Bhagat Ram, AIR 1975, the Supreme Court, following the test laid down in Electricity Board Rajasthan's case by 4-1 majority. Justice Algiriswamy, dissenting, held that Oil and Natural Gas Commission, Life Insurance Corporation and Industrial Finance Corporation are authorities within the meaning of Article 12 of the Constitution and therefore, they are state. All three statutory corporations have power to make regulations under the statute for regulating conditions of service of their employees. The rules and regulations framed by the above bodies have the force of law. The terms of contract with a particular employer is prescribed by the statute itself. These regulations are binding on these bodies. The employees of these statutory bodies have a statutory status and they are entitled to declaration of being in employment when their dismissal or removal is in contravention of statutory provisions. The employees are entitled to claim protection of Articles 14 and 16 against the corporation. Justice Matthew, in a separate but concurring judgment, preferred a broader test that if the functions of the corporation are of public importance and closely related to governmental functions, it should be treated an agency or instrumentality of government and hence a state within the ambit of Article 12 of the Constitution. The effect of these decisions was that the authorities not created by the Constitution or by a statute could not be a state within the meaning of Article 12 of the Constitution. This was a very restrictive interpretation of the expression, other authorities under Article 12 of the Constitution. But in subsequent decisions, the Supreme Court has given a broad and liberal interpretation to the expression other authorities in Article 12. With the changing role of the state from merely being a police state to a welfare state, it was necessary to widen the scope of the expression authorities in Article 12 so as to include all those bodies which are, though not created by the Constitution or by a statute, are acting as agencies or instrumentalities of the government. In modern times, a government has to perform manifold functions. For this purpose, it has to employ various agencies to perform these functions. The court has, therefore, rightly taken the view that such juridical persons acting as the instrumentality or agency of the government must be subject to the same restrictions as the state. In Airport Authority's case, Justice Bhagwati preferred, and rightly, the broader test as suggested by Justice Matthew in Sukhdev vs. Bhagat Ram case. In this case, the court has held that if a body is an agency or instrumentality of government, it may be an authority within the meaning of Article 12 whether it is a statutory corporation, a government company or even a registered society.